Good morning, everyone, and thank you for joining us today. Welcome to our webinar on ethics. I'm Jeanette Stanziano, Director of Education and Training for your New York State Association of Counties. On behalf of our President, the Honorable Martha Sauerbrei, and our Executive Director, Stephen Aquario, and the NYSAC Board of Directors, I welcome you to county government and congratulate you on your election or appointment. If you're here to refresh your training, this is a great place to do it, and we thank everyone who was logged on in that capacity to join us today. Welcome to county government. NYSAC's mission is to represent, educate, advocate for, and serve New York's counties and the thousands of elected and appointed county officials who serve the public. As the voice of county leaders throughout New York State, NYSAC is steadfast in communicating the needs and recommendations of our county officials to state lawmakers. Local government is at the heart of New York State, and NYSAC is proud to represent the counties and their elected and appointed officials throughout New York. I'd also like to make you aware of our upcoming webinars. The last two modules of this orientation training will happen on January 12th, which is also a Thursday. That's module 4. And that program will be discussing adopting local laws. Basically, they'll be discussing the powers granted to local legislators under the state's municipal home rule law, the county law, and other relevant statutes will be addressed. The presentation will focus on the procedures and requirements that must be followed by county legislative bodies to enact local laws. Part 2 of the webinar on January 27th will feature a presentation by Shoshana Bewley, who is the Executive Director of the New York State Committee on Open Government. She'll be presenting on open government laws and be discussing the requirements of the state open meeting laws and other relevant statutes will also be detailed in her program. The responsibilities and legal requirements of county elected and appointed officials to govern in the sunshine will be featured. Module 5 and our final module of the orientation will be held on February 3rd at 10 a.m. There will be 2 parts to this program, the first part being the role of county clerks of legislative boards. Michael Billard, the president of the Association of Clerks of County Legislative Boards, will be presenting, and they'll be providing information on the many vital services and resources that clerks of legislative boards provide county officials. The second part of the program will be NYSAC programs, services, and education and training. We will have many people from our staff who will discuss various departments at NYSAC and different services that we provide, including services, other legislative programs and initiatives, education and training in terms of our conferences, and also we will be presenting information on our communications department and all the different tools that they have for county officials to stay in touch. So that's what's coming up. Just a couple of housekeeping measures before we begin. This program is being recorded, as all of our webinars are. It will be posted on the NYSAC website with a copy of the slide deck. Later today, you can find this recording and PDF at nysac.org/webinars. Just look under archive webinars for today's date, and you will find this probably by about 1 p.m. today. It will be posted by then. So now I would like to introduce our speaker for today. Stephen Leventhal is an attorney and a CPA with extensive experience in the areas of securities arbitration, commercial litigation, tax planning and litigation, business relations, real property transactions, professional ethics, wills, trusts, estate planning, and probate, among others. Mr. Leventhal has lectured and written extensively on the subjects of government, legal, and corporate ethics. He's frequently engaged to provide ethics advice, training, and continuing professional education programs to municipal officers and employees throughout the state, municipal associations, bar associations, law firms, and universities. On a personal level, Steve has been my go-to ethics guy every time we've needed an ethics training because he is simply one of the state's experts. We are very happy to have him today. And I would like to turn the program over to him right now. I think that's about it for housekeeping. One other point, we encourage you to submit questions throughout the program, and we ask that you do so by going to your dashboard, looking for the questions tab, and typing in your questions through the dashboard. You can do that at any point throughout the program. We will get to questions during the Q&A at the end of the program in the last 15 minutes or so. Okay, now I'm going to turn the program over to Stephen.
Good morning, everyone. Let me begin by saying that I hope that all who are listening are safe and well, and that the same is true for your loved ones. I'm sure that we all share the hope that we'll get through this very difficult time quickly and return to some kind of normal. Ethics is eternal. It changes very little, but it's important to understand what we mean when we use the term ethics. There's a natural tendency for people to think that the word ethics and the word morality mean the same thing. But in my opinion, it is inaccurate and unhelpful in the government ethics context to think of ethics and morality as if they mean the same thing. And here is the example that I think illustrates that point. I take it as an article of faith that each person participating in this webinar is honest and truly wishes to do the right thing and will do the right thing if called upon, if presented with a conflict of interest. I'm willing to bet that you could recognize where your personal interest lies and where the interest of the county lies and the public interest. And you would take the action that advanced the public interest even at the expense of your own. If you were to do such a thing, that is, act in the face of a conflict of interest, but take the action that advances the public interest, would you have done something immoral? Certainly not. Would you have done something unethical? Absolutely, you would. And the reason is that even an innocent conflict of interest has the effect of reinforcing in the minds of a skeptical public the idea that government is being run to advance the interests of the insiders rather than to advance the public interest. So we adopt ethics rules to achieve two purposes, which I'll address in a moment. But the screen that you see is essentially a list of the topics covered by Article 18 of the New York General Municipal Law. That is the statewide code of ethics that applies to every municipality in the state, with the exception of the city of New York. You can go to the next slide. And now the one that follows. So the purpose of local government ethics laws is twofold. It is to foster integrity in government and to promote confidence in government, but also to guide and protect honest county officials and help them to stay out of trouble by avoiding unintended ethics violations. That is really the most important function of all of a local government ethics program, because the logic and experience indicate that the vast majority, the overwhelming majority of local government officers and employees are honest and truly wish to do the right thing. The trick, of course, is to know what to do when faced with a conflict of interest. So let's go to the next slide. The ethics code covers all officers and employees of the county, and that includes uncompensated members of boards and commissions. So virtually everyone is covered by the Code of Ethics. There are some informal committees that are at times established where people are uncompensated, they have no decision-making authority, and the local beautification committee comes to mind. There are some committees that would not, whose members would not qualify as officers and employees for purposes of compliance with the code, but the overwhelming majority of other board members, departmental employees, agency appointees, all are covered by the Code of Ethics. In most instances, unless there is a local law to the contrary, independent contractors are not covered by the Code of Ethics. So let's go to the next slide. Nearly every conflict of interest, not everyone, but most, and I'm going to talk about those that are not, but most conflict of interest can be cured by recusal. It is, there are two common misconceptions that people have about what we mean when we use the term recusal. The first is many people think that recusal and abstention are interchangeable terms. They're not. When you abstain from a vote, if you're a member of a voting body and you abstain from voting, it can be for any number of reasons. You may feel that the voting body does not have enough information. You may feel that the timing of the vote is wrong. For example, if you're the member of a board or commission that meets in the evening and the weather is bad and the public has stayed at home and you think that the action should be taken when more members of the public can be present, there can be any reason at all for you to decide that you're going to abstain from the vote. A recusal, on the other hand, occurs in the face of an actual or potential conflict of interest. Because you have an actual or potential conflict of interest, you refrain from any participation in the matter at all. You do not participate in the discussions, the deliberations, or the vote. That is not true of an abstention. When you abstain, you may have tried to persuade your colleagues to see it your way. You may have participated in the discussions and the deliberations, but not the vote. You've abstained from the vote. In a recusal, you must have nothing to do with the matter, and the Attorney General has recommended that when you recuse yourself, you leave the room while the matter is being discussed. In my practice, I represent smaller municipalities who don't have sophisticated facilities where someone can sit in one room and listen to the proceedings that are taking place in another and know when to return. What I generally advise my clients is if a matter comes up and you are recusing yourself, get up off the dais, go sit in the back of the room and don't participate. But leaving the dais at least is a very valuable visual demonstration to the public that you are removing yourself from any participation in the matter. The second misconception that many people have about recusal is they think it's a neutral act. But there is a law in the state of New York, the General Construction Law, construction not as in erecting a building, but construction as in construing laws. And General Construction Law Section 41 says that in order to determine whether a voting body has achieved a sufficient number of votes in favor of a measure for the measure to carry, you compare the number of votes in favor to the number of seats on the body, whether those seats are occupied or not. So just to make the arithmetic easy, let's say you have a 5-member board and there's one vacancy that the appointing authority has never gotten around to filling, and one member recuses himself or herself. And Now there are 3 members participating. Do you have a quorum? Certainly you do. 3 out of 5 is a quorum. Now the matter comes to a vote, and 2 vote in favor and 1 votes against. Does the measure carry? No, it does not, because in order for a measure to carry, when there is a 5-member body, you must have 3 votes in favor, even if there are vacancies, even if there are recusals. So for that matter, a recusal is really the functional equivalent of a nay vote. For that reason, we want people to be conservative, we want people to be conscientious, we want people to recuse themselves when they have a conflict or feel they might have a conflict, but we don't want them to recuse themselves for frivolous reasons, because your vote is necessary often to achieve to enable the body to function. Okay, let's go to the next slide. So actually, this hypothetical is an illustration of what we mean by recusal. It goes on for 3 slides, and I'll summarize it. And I described it as a hypothetical. It's really an actual case. This is a real case. A subdivision developer hired a member of the town board in this particular town to be the general contractor on the project. They had a falling out over payments to subcontractors, and the town board member was replaced as general contractor. Later on, after the project is partly built out, the developer comes to the town board. I've recast it in this slide as a county project, but it's a town project in the actual case. The developer comes to the town board and says, I've built enough of the project, I'd like you to release my performance bond so I can get my money back. The town engineer advises the town board against releasing the bond because the engineer says not enough of the construction is complete. If you accept dedication of the road, which is a necessary predicate to release of the bond, if you accept ownership of the subdivision road, the construction vehicles passing over that road when the construction is completed will tear up the road. You'll have a road full of potholes. Wait until more of the construction is completed. So the town board turned the contractor down. The contractor sued. The contractor said that the town, and in denying the request of the contractor, the town board member who had been the general contractor and who was replaced recused himself. So now the developer sues the town and says to the judge, the only reason the town board turned me down is because the town board member that I fired as the general contractor is out to get me. And he persuaded his colleagues to vote against me. The town attorney said, Judge, here's the transcript of the proceeding. It says here that that member recused himself. The developer said, nonsense. That's what he said on the record. We all know what he did behind the scenes. We all know what they did before they came out in public. He badmouthed me. He persuaded them to vote against me. The judge said, in deciding a motion to dismiss, we don't know what actually occurred here, but if the developer is able to prove that what he says happened did happen, he'll win. Because a recusal means that you remove yourself entirely from the matter and you don't influence your fellow board members. I have seen cases in which a board member in one municipality or another has an interest in the matter and says, ladies and gentlemen, I'm recusing myself, and gets up off the dais and goes and sits in the audience and speaks for or against the project. Well, in my view, that is improper. You cannot do from the audience what you are unable to do from the dais. And you might say, but wait a minute, don't I have rights as a member of the community? Don't I have First Amendment free speech rights? Aren't I entitled to speak my mind at a public meeting of my local government in support or opposition to a project? Well, the answer is yes, you do. You're free to step down from your official position and enjoy all the benefits that other citizens have who don't have the added obligation to comply with ethics rules. The point is that it's inconsistent to act in that manner if you're also a member of the body. So that is the meaning of that case, and we'll move on to the next slide. Now, I mentioned Article 18 of the New York General Municipal Law. Here is how we analyze an ethics problem in the state of New York. It's really a three-step process. I don't expect anyone to leave this webinar with these steps memorized or be transformed during the 1 hour that we have here this morning into an expert on these laws. But I'm going to tell you the process so that you can understand the conceptual framework of our ethics program. Article 18 is the statewide code of ethics. It applies in all municipalities. So the first of three questions that you must ask yourself is whether the contemplated conduct violates Article 18 of the New York General Municipal Law. If it is, you need go no further in your analysis. The conduct is prohibited. But Article 18 authorizes local municipalities to adopt their own local codes of ethics, provided that those codes can prohibit conduct that Article 18 would allow, but they may not allow conduct that Article 18 would prohibit. So even if the conduct is allowed by Article 18, you must go to the next step and determine whether that conduct is prohibited by your local county code of ethics. I'd like to be able to say that those two steps are it, that you need go no further, but there's a line of cases that we'll talk about going back to the 1970s, in which courts have said even conduct that doesn't violate state or local law may be prohibited if it's really bad. This is sometimes called the prohibited appearance of impropriety, and that concept is not applied lightly. It is applied only in very serious cases where the conflict of interest is clear and obvious, where it's not speculative, where it involves actual self-interest, prejudice, or some other very serious misconduct. So this rule, the rule that's up on the screen, is the most important one. It's the core rule of the statewide code of ethics. It's the main ethics rule in the state of New York. It is the rule against prohibited interests in municipal contracts. A municipal officer or employee may not have an interest in a contract with his or her own municipality if she has any control over the contract, unless an exception applies. There are three elements to this violation: a contract with the county. The officer or employee does not need to be a party to that contract. All that's necessary is that there be a contract, and the term contract is broadly defined for these purposes. It includes a claim against the municipality. So the first element is a contract. The second element is an interest or a benefit flowing to the officer or employee, or a spouse, or a business in which the officer or employee is a partner, an officer, a director, or the owner of more than 5% of corporate stock. So the first element is a contract. The second element is a benefit flowing to the officer or employee, or a person or entity closely related. And the third element Also necessary for there to be a violation is that the interested officer or employee, either individually or as the member of a board, has the power or duty to control the contract. What do we mean by control? Control means the authority to approve the contract, to approve payments under the contract, to audit bills rendered under the contract, or to hire or fire anyone who has the power or duty to do any of those things. So the three elements: a contract, the second element, a benefit flowing to the officer or employee, and the third element is that the interested officer or employee has some control over the contract, either individually or as a member of a board. And because the control arises from the mere membership on the board, recusal will not cure a violation of this provision, as you'll see in some of the examples that follow. And as you'll also see, there are statutory exceptions. There are particular exceptions to this rule. Now, this is a tough rule. This rule prohibits a contract even if the contract is in the best interests of the municipality. As we'll see, the contract is prohibited. So let's go to the next slide. A county solicits sealed bids for a major renovation of a county office building. The wife of one of the bidders is a county legislator, but she completely recuses herself from having anything to do with the project. The husband's firm proves to be the lowest bidder. Can the county award this contract to the spouse of a legislator? The answer is no. Let's return to those three elements. You have a contract with the county, this contract for renovating the office building. You have a benefit flowing to an officer or employee in the form of the compensation that the spouse will receive. And the officer or employee, as a member of the county legislature, has the power or duty to approve the contract. So this is a prohibited contract. And the fact that it was put out to sealed competitive bids does not save the contract. The fact that the legislator recuses herself does not save the contract. The contract is prohibited. Let's go to the next slide. The county clerk requires approval of the planning commission to partition her residential property. The planning commission grants the application. Is that a contract? Well, one local trial court many years ago ruled that an application to a zoning board and the zoning board's approval constituted a contract with the municipality, but no appellate court has ever taken a similar view. No other trial court has taken a similar view. And I think that that case was wrongly decided. A mere application to a land use board by the owner of residential property, even if that owner of property is an officer or employee, would not constitute a prohibited contract with the municipality. Given the right set of facts, it might violate some other ethical rule, but not this one. So let's go to the next slide. When leaving a restaurant with her family one Saturday night, a county legislator is struck by a county vehicle. The legislator sues the county. Is the lawsuit a contract with the municipality? Well, the answer is yes, because as I said earlier, the term contract for purposes of this rule is broadly defined, and it includes claims against the municipality. Many people, when I have the luxury of being face-to-face with an audience, are surprised, offended, outraged by this rule. How can you take away from a county officer or employee the right to sue the municipality to recover for damages, recover for injuries? The answer is we're not taking that right away. If it's important enough, if it's a big enough claim, the county legislator can step down, resign from her office, and then she's free to sue the county. But a county legislator cannot sue the county to recover money damages in a personal injury action. I recently had a matter down here on Long Island, where I'm from, in which a town supervisor sued the town board, challenging certain labor actions, personnel actions that were taken by the town board immediately before she took office. That was not a violation of this rule, and the reason is that she was not seeking to recover a benefit for herself, as is the case here with the money damages. She was taking that action in her official capacity to vindicate what she saw as proper discharge of governmental duties. And so you didn't have that second element of an interest in the litigation, in the claim. Let's go to the next slide. The county legislator is the executive director of a nonprofit social services agency that has a contract with the county. A portion of the legislator's salary as executive director will be paid by the county contract. Is the contract prohibited? Well, you might be tempted to say yes, you have a contract, you have a benefit going to an officer or employee. The officer or employee is a legislator. Is the contract prohibited? No. And the reason is that there is a specific exception in the statute for contracts with voluntary not-for-profit organizations. Now, that means that the contract is permitted. It does not mean that this legislator can or should vote to approve the contract. Here, recusal is necessary because the legislator will benefit from the contract, but the contract itself is not prohibited. Next slide. The wife of an insurance agent who has an insurance contract with the county is elected to the county legislator. Does the legislator have a prohibited interest in the county's insurance contract? Well, you have a contract with the county. You have a benefit flowing to the spouse in the form of premiums, commissions on the insurance premiums. And this individual is now a member of the legislative body that has the power to approve the contract, to order bills under the contract, to approve payments and so forth. But there's another exception in the statute. It's the grandfather clause. Because this contract was entered into before the legislature was elected, it is grandfathered in. But when the contract comes up for renewal, can the county approve a renewal of this contract? The answer is no. Under those circumstances, the contract would be prohibited. Next slide, please. Okay. If you have an interest in a municipal contract, in a county contract, Article 18 of the General Municipal Law requires that you disclose that. And as I mentioned earlier, or didn't mention earlier and should have, recusal is always coupled with a disclosure. If you recuse yourself, you state the reason why. It doesn't have to be in great detail, but you couple recusal with a disclosure of the conflict of interest or potential conflict. Next slide, please. This rule, disclosure of interests in applicants in land use matters, is one that applies actually to members of the public. If an applicant files an application in a land use matter, such as a zoning change or approval of an application filed with the County Planning Commission, a building permit, other land use applications. That applicant must disclose at the time of application the identity of any municipal officer or employee who has an interest in the applicant, not an interest in the application, but an interest in the applicant. If the applicant, for example, is XYZ Contracting Corp., and a deputy in the clerk's office owns 20% of the corporate stock, that ownership interest must be disclosed in the application. And I'm sure that if you check, you will find that your applications, your form applications that are used by your land use boards and commissions and agencies contain that question. And if it doesn't, it should. It's something worth checking. Next slide. Moonlighting. This rule is not from Article 18 of the General Municipal Law. This is a common law principle, but it is an important one. It affects enough people so that it's worth mentioning here. You can't have an outside job that conflicts with your duties as a county officer or employee. How do you know whether the job conflicts with your official duties? Well, believe it or not, the leading case that answers that question was decided in 1874 by the New York State Court of Appeals. That's the state's highest court. And that case, People ex rel Ryan versus Green, says that in the absence of a constitutional or statutory prohibition, you can hold two offices or one office and a position of outside employment, provided that the two positions are not inherently incompatible. How do you tell whether they're inherently incompatible? You look at their duties. So the classic example of two incompatible positions is chief financial officer on the one hand and auditor on the other. You can see how the duties of an auditor and the duties of a chief financial officer are incompatible with each other. It is sometimes said you can't be your own boss. But if you are thinking of taking a second job, you should, and you have any doubt about whether the duties of that outside position conflict with your official duties, you can ask the Board of Ethics for a confidential advisory opinion. Every county government is required to have a Board of Ethics. That is a requirement imposed by Article 18 of the General Municipal Law. And the Board of Ethics is available to provide confidential advisory opinions. I have frequently lectured with a colleague who until recently was the executive director of the New York City Conflict of Interest Board, where he served for many years. And I've heard him asked many times, who do you think was the most frequent customer for ethics advice from the New York City Conflict of Interest Board during the many years that he was its executive director? And the answer may be a surprise to you. The answer was Mayor Bloomberg. Now, of course, we all know Mayor Bloomberg is a billionaire of great wealth, as if there's any other kind. But his wealth is very, very large, and he more than anyone you might imagine would have had the ability to hire his own army of private attorneys to give him all the ethics advice that he could possibly need. Why did he go to the New York City Conflict of Interest Board for advice? Because he was smart, and he understood that if he had an opinion of the New York City Conflict of Interest Board blessing the action that he proposed to take, that opinion made him bulletproof. So too, if you obtain an opinion by your Board of Ethics saying that the conduct that you are contemplating would not violate Article 18 or your local code of ethics that will immunize you from criticism. Courts give great weight to the opinions of local boards of ethics. Next slide. This rule is a very difficult one. You may not disclose confidential information or use it for a non-county purpose, even after you leave county service. Why is this a difficult rule? Because the term confidential information is not defined. And I will tell you that if you ask the Committee on Open Government what information is confidential, they will say that the only information that is confidential is information that is prohibited from disclosure by federal or state law. Federal law, for example, prohibits the disclosure of your private medical information, that's HIPAA. State law prohibits the disclosure of a variety of types of information, for example, the attorney-client privilege. If you consult with me, I am prohibited from disclosing the confidences that you disclose to me for purposes of obtaining legal advice. So I would add another category of information to that short list of what constitutes confidential county information. As you know, both the Freedom of Information Law and the Open Meetings Law authorize county governments to withhold certain information from the public, to deny requests for inspection or copying of records, and deny access to a meeting where certain categories of information are being discussed. Now, the fact that the municipality has the discretion to withhold that information doesn't automatically make it confidential, in my opinion, such that its disclosure would be a violation of the ethics regulations. But in my opinion, if the county has lawfully determined to withhold the information, if the person properly authorized to make that determination has decided to withhold the information, then that information, in my view, becomes confidential for purposes of the ethics code. Next slide, please. Okay, this is a very important one, and as I have met people around the state, it's a rule that causes difficulty for, in particular, for smaller municipalities who have more difficulty populating their boards and employment positions. This rule says that you may not receive payment for services in any matter pending before your own agency, department, board, or committee. So let's go to the hypothetical on the next page. Let's go to the next slide. Okay, the member of the County Planning Commission is an architect. This happens all the time. You populate these boards with architects, with engineers, because they have the expertise that is an important resource to the board in discharging its duties. So a member of a county planning commission is an architect. His client applies to the planning commission for approval of an application and site plan prepared by the planning commission member. The planning commission member recuses himself from the discussions, deliberations, or vote on the application. This often comes up. The chairman of a local planning board will announce before an application is heard, I'm the architect on this application, or I'm the engineer. I recuse myself, and gets up and sits in the audience next to his or her client while the matter is heard. Well, that is prohibited. It is prohibited by the rule that says you can't receive compensation for a matter pending before your own agency. What is the reason for that rule? The reason is we don't want to give the public the impression that their application is more likely to be granted if they hire a member of the board or commission that they must make the application to. We want there not only to be a level playing field in reality, but we want there also to appear to be a level playing field, because that's an important building block for public confidence in local government. Okay, next. Representing others, contingency fees. You all know what a contingency fee is. It's one that personal injury lawyers typically charge. They say, I won't charge you anything unless we win, and then I'll get a third, or I'll get 20%, or whatever it is you've negotiated. A contingency fee is a fee based on the outcome, and you may not receive a contingency fee on a matter pending before any agency, department, or board of the county for which you are an officer or an employee. Now, before we leave this topic of being compensated for matters before your county, remember, I'm giving you the rule based upon the state law. Your local code of ethics may have a stricter rule. It may regulate or even prohibit any income, whatever, being derived from matters before your county. You must check the local code. Next. All right, this is needless to say a very important rule, and I see that we're getting near the time for questions. So I'll make this the last topic that we discussed, but it's a very important one. The rule in Article 18 that prohibits gifts and favors is a vague and unhelpful rule. It says that you may not request a gift of any amount or accept a gift having a value of $75 or more under circumstances where it would appear that the gift was intended to influence or reward an official act. The important thing to understand here is that the ethics rule related to gifts is all about appearances. If the gift is actually intended to influence or reward an official act, it is a crime. If it just appears to do so, it's an ethics violation. Next slide. This is just an illustration. A county legislator and a local developer are friends. They celebrate their birthdays together each year. They treat each other. They go out with their spouses. The meals cost more than $75. Is it a violation if the legislator's friend now has an application before the legislature? The answer is no, it's not an ethics violation, because the history of these couples socializing together indicates that the meal, the complimentary meal, has not been given for the purpose of influencing or rewarding an official act. It's consistent with their long history together. All right, I want to just skip to, well, let me make these 2 points, and we don't even have to look at any further slides before we take questions. A campaign contribution. A campaign contribution is not, oh, go back please to the one just before, the bribery slide, and leave it there. Good, thank you. A campaign contribution is not a gift. It's regulated by the election law. It's a different species of animal than a prohibited gift for purposes of the ethics code. Generally, they go to campaign committees. There are First Amendment rights that are involved. And finally, I made the point that if a gift is actually given for the purpose of influencing or rewarding an official act, it's a crime. And we all know what bribery is. Bribery is a corrupt deal. It's a deal made in advance. I'm going to compensate you in some way for taking an official action or refraining from doing so. We're both guilty of a crime, and the crime is either a misdemeanor or a felony, depending upon the degree of misconduct involved and the amount of consideration exchanged. But there's a lesser known crime the crime of giving or receiving an unlawful gratuity. It's a misdemeanor, and this crime is committed even if there is no deal in advance. If a gift is given as a reward for something that it was your job to do in your official capacity, it is a crime to give or receive such a gift. There's no dollar threshold. It doesn't start at $75. It starts at $1. And to state this rule in a nutshell, there is no tipping in government. There is no tipping in government. I know that it's a common practice in some municipalities for sanitation workers to receive gifts, tips, for others to receive gifts at holiday time, but it is a crime if it is given as a reward for doing your job. I think I'm going to leave it there.
Thank you so much, Stephen, for that really insightful presentation, as always. We are now going to cover, there really were only a couple of questions that came in, and let me just get to those right now. I'd like to introduce NYSAC counsel, Pat Cummings, who is here to field some questions for us. Pat, are you on the call? Well, it sounds like Pat is still tied up. So what I'm going to tell everybody is that we have just 2 questions, and I will be sending the answers to those 2 individuals via email after the presentation completely. I'd also like to thank our Excelsior sponsors for underwriting this program today. They do a lot for us, and we really appreciate their commitment to county government. Thank you for everybody for joining us today. I'd like to especially thank Stephen for giving us his time once again and his expertise. We hope you can join us for the upcoming 2 programs that we talked about earlier. And until then, stay healthy, and I hope everybody has a productive week. Thank you so much.